What is the possibility of having a company as a appointer?
Company appointer, yes, that's quite common. And so the question is being a company appointer of a trust. Now, we actually do use that in the context of succession planning because we can put that ultimate control of a trust within a company, and then we can control how that's used or organised among family members through the constitution of the company. So just taking a bare right to appoint a new trustee and then turning it into a whole control structure through the constitution of the company we use that quite a lot in succession, in business succession and wealth succession. So the short answer is yes, you can do it, and it is relatively common. And it sort of is in line with that concept that I was talking about as far as embedding a fiduciary type rules around that appointer role rather than just having a straight appointer. Yep. Thank you. One more?
The veto part, how you can put a veto into company structure?
So basically the question there is putting vetoes into companies, so where the shareholders can actually stop directors doing something. You need to embed that within the constitution, and you actually require the authority of directors is set by the corporations law and the constitution. It's not an unbridled authority just because you're a director. So a normal constitution gives directors, when you read the constitution, the first couple of pages is all the powers of the directors. They can borrow, they can grant options, they can do all these things. You can limit what they can do, and you can put vetoes or things they can't do without certain consent or just can't do full stop. So we do a lot of work around constitutions where people want to think about how their businesses are going to be managed and run, and the interplay between the shareholders as passive owners and the directors as active managers of the business. So constitutions are actually a really fun area to play in if you want to address those issues as far as how a business is going to be run rather than just the director doing everything.
So you can avoid basically shareholder agreement in this case.
Sorry?
You can avoid shareholder agreement if you want.
Exactly, yeah, and we recommend constitutions as opposed to shareholder agreements.
Can you change the current constitution of the company if we come to you and?
Yes, definitely. Yeah, absolutely. Yep. No, we like doing that sort of stuff. Yep. Thank you. Anybody else?
What's your view on the effectiveness of directors' and officers' insurance to protect against personal liability?
Excellent. Yep. One of the things on the contractual asset protection, which I've actually got a paper on this, but it's in the paper, but I didn't put on the slides, which is directors and officers' insurance. And this is, there's two things. There's insurance, and then there's usually an indemnity where the company says that the assets of the company can be used to indemnify a director in relation to a personal liability of the director. So the question is, what's our view of the effectiveness of it? I've looked at it from two perspectives, one as an advisor and one as a director, and at one stage I was on a small public company, and everybody told me that it wasn't worth having, but I must say I really enjoyed having it. So I would say that it is, you don't hear a lot of instances where it's paid out. I think it's very valuable in the context of costs, so solicitor costs, defending things, so working out whether you're liable or not. It's perhaps less effective in really dealing with the underlying liability that they're trying to shoot home to you. The context of insurance for insolvency I know is very difficult. And the other comment I'd make about D&O insurance is make sure you get tail-off insurance. So your obligations as a director don't end when you cease to be a director. They can come home to you for a period of, a long period after, for environmental issues, for example, after you cease to be a director. So require your indemnity and your general insurance to have a tail-off obligation on the company, which means they've got to keep paying premiums for you for a period after you cease to be a director.
We should thank Andrew for his presentation.